The Supreme Court is throwing out rulings in favor of transgender people in 4 states, and this follows the justice's recent decision upholding a Tennessee ban on certain medical treatment for transgender use. But the justices took into action, I should say no action, in cases from Arizona, Idaho, and West Virginia involving the participation of transgender students on school sports teams. So the High Court now is also ordering judges to re-examine cases from those states, including right here in North Carolina, that involve access to medical care and birth certificates. A lot to be able to discuss this here. Let's bring in Chief Legal Analyst Khalif Rhodes. First, let's explain this whole decision. I know you got your papers all lined out here, Khalif, but explain what we need to understand from this.
Yeah, this case is, I'll say, different than I anticipated for a couple of reasons. And Justice Sotomayor kind of hit on where I was thinking the court was going to go in her dissent. This was one across party lines, but the main case, the Scrimeti case that comes out of Tennessee, 63 opinion, they upheld Tennessee's in the ban banning hormone therapy. And the banning of it and the upholding of it is really not the issue that I had, but it's the lowering of the standard of review, and that's what Justice Sotomayor said. There's 3 standards of review when you're looking at a constitutional question. You have strict scrutiny. That's our highest level, right? That's like jumping over a mountain. If they apply the strict scrutiny standard of review, the government really is hard for them to make that connection. It has to be a legitimate government interest. It has to be narrowly tailored, has to be compelling government interest, say, in a narrowly tailored. This intermittent scrutiny, that's when it has to be a legitimate government interest. And the lowest standard, and that's the standard that they applied here, is this rational basis. The government just has to show that it was rationally connected to a legitimate purpose. That standard is so low that anytime those type of cases come before the court, then you will see that the government will usually prevail. And so history would show that this type of case, based on something regarding sex, even since the 70s, has been at least at that intermittent scrutiny level. Justice Roberts, writing for the court, said that there is no constitutional issue here and that it should be done at the rational basis standard, which Sotomayor said that she started off by saying, sadly, I dissent. I mean, that lets us know when you read that dissent that she was disappointed by the court's thought process on how they got here, and that clearly this is something that was discriminatory on its face, and not just discriminatory on its face, but discriminatory based on sex. So she thought that the standard should be, at the minimum, the intermittent scrutiny, and I would agree. Even if the court went another way and decided that they would still rule in the government's favor, it made sense to keep the standard of review at intermittent scrutiny, so they would have to at least show more than just a rational connection, but they'd have to go over that that higher burden, and the court did not believe that was the case.
So understanding this, especially how it applies here to North Carolina, the High Court ordered the appellate judges to re-examine cases from other states like Idaho, but also here in North Carolina. What does that mean?
Send it back. Go down and look under this review standard that I just talked about. They're going to have to go and look at these cases that they've already looked at before under this higher scrutiny, and where they found that under the intermittent scrutiny standard, that those laws in those states didn't meet the standard. This court now is saying, go back and review it under a rational basis. So, I mean, I don't need a crystal ball to tell you that once these cases go back and they use the rational basis standard, what's going to happen is they're going to now find that the government has met their burden, and those rules and statutes that have been implemented in those individual states will be allowed to go forward, when before, under the higher standard, they were ruled unconstitutional.
Khalif Rhodes, appreciate your insight. Thank you so much.
Queen City News Plus. Just search Queen City News on your smart TV's app store.